we find it very valuable. We now have 2 experts on arbitration clauses and force majeure. The wonderful Stephanie Klein, Robert Allen Law, and Daniel Butler, Luxury Law Group, with offices on Las Olas. Now, I'm going to really turn this over to both of these experts because the last thing you want to do is speak on anything legal with Danielle and Stephanie, so I'm just going to be quiet. The timer will be set, and you have the floor.
Hi, everyone. My name is Stephanie Klein. I'm an attorney at Robert Allen Law. I'm really excited to be here. Unfortunately, I wish I was talking about something a little bit more exciting than an arbitration provision, but I'm going to make it as interesting as I possibly can for you guys. So a lot of you use the MIBA form, right, as your standard charter agreement. But a lot of you also have American clients who are chartering their boats in the Caribbean or in the southern or in the Western Hemisphere in general. So while MIBA is a really good form to use, it's not perfect, and that especially applies to the dispute resolution provision, which is the arbitration provision. So what we're going to do today is briefly look at what you should be looking out for when you have an American client, they're going to the Caribbean, you're on a MIBA form, and with respect to your dispute resolution provision. So this is what we're going to talk about. So all contracts should have a dispute resolution provision in them. MIBA has one. It's buried towards the end. It's under a lot of other legal mumbo jumbo that, let's be honest, you guys probably are not reading, and your client, I want to say definitely, is not making it to page 7 of the 8-page MIBA form. And really, only lawyers are reading this stuff in detail because we write it, we have to deal with it every day, and honestly, it's just not that exciting. So today we're going to talk about 3 things. We're going to look at the arbitration clause under the standard MIBA charter agreement. We're going to talk about when and how it can be changed and what it should be changed to. All right, so. All right, this is part of the clause. It's clause 23. It's on page 7 of 8. Like I said, if you make it all the way to page 7 and you make it to this clause, good for you. I'm proud of you. Like I said, it's hard to get through that first 7 pages. Not to mention the whole arbitration clause takes up a half of a page. So I didn't want to put the whole thing up here for you because it's a little bit too much, but this is what you need to know with respect to your clients. So it's arbitration, right? It's under English law that arbitration is going to be binding. It's going to take place in London under the London Maritime Arbitrators Association terms. So let's think about how this works, right? You have your American client. He's chartering in the Bahamas. If he has a problem and he wants to file a claim, what's he going to have to do? He's going to have to hire an English lawyer. He's going to have his arbitration in London, which means he's going to have to travel there maybe a few times. What this really means for your client and what he's going to think. Not that. I don't know what that is. Should I click it again? No, he's not going to think sea turtles. All right. So we'll just keep going. But yeah, so we had a really cute thing up here with dollar signs everywhere. Because, right, that's what it means. You know, you've got to get an English lawyer. You're going to London, excuse me. It's going to be a mess, right? I mean, your client doesn't want that. You don't want to be involved in that. It just doesn't really fit, right, when you have most of the clients that you guys have. So let's talk about how you can change it. All right, cool. There we go. That's what he's going to see. Yep. And he might even have that face on it, like, oh, God, really? I've got to go to London? No. And an English lawyer? No. Okay, so let's talk about how it can be changed. You guys use the standard form. You look at it. It's not meant to be modified, right? Because everything's pretty much set in stone. You have that first page. You fill in your details. That's about the extent of what you guys are doing. But it can be changed, and you need to know that. It can definitely be changed. Every contract can be changed. When should it be changed? Always, always, always before it's signed. You should never sign a standard contract and think after the fact, well, you know, we'll worry about it later and we'll amend it later. No, you need to think about it before, have the parties agree on what's going to happen before, and then and then sign it, obviously. So there's two ways that you can do the amendment, and we'll talk about both of them. So what we usually see happening, the first way, and not necessarily the best way, is this. So you have a page in MIBA where you can write in your special conditions, right? And what we see a lot of brokers doing is saying, all right, I'm going to jot this line in here. The parties agree that the location for arbitration will be in Florida. And you think, great, we're good to go. I knew it was English law, I knew it was in London, but we're going to be in Florida now. Well, you'd be wrong, actually. Because now what you're going to have, because you didn't amend the whole provision, you know, that half page, there's a lot of stuff going on in there. You just wrote this. You're going to have English law. You're going to have arbitration under the London Maritime Arbitrators Association. But all this is going to happen in Florida, right? And sounds like a real mess. That's because it is. Your client's not going to be happy, and he's going to be like this guy. He's going to be thinking, no. Unfortunately, he's going to be stuck with it, right? So he's going to be unhappy because he still has to hire that English lawyer. That English lawyer is going to have to travel here. You're still under English law. Really, it's just a mess. So what you need to know, it's a huge liability for you guys to just start writing stuff in that page and really not knowing what you're modifying and what you're amending and what you're doing. You need to know exactly what you're doing, and if you don't, you need to talk to a lawyer and get some advice on you know, how you get what you need and you want into your contract. So this leads me to the preferred way to modify the contract. Have your lawyer draft an addendum. The addendum and the contract would be signed at the same time. And the benefit to this is you can change anything else in the form that you want. You have special conditions, considerations. You can put it in the amendment as well. I think Terry mentioned a minute ago, we don't like to get lawyers involved because the budget isn't really there, but it's not on you, it's on your client. It's a protection for your client. Advise your client, hey, have a lawyer take a look at your contract before you sign it. You know, it's just the best advice. So, you may be wondering, what do we change it to? Whatever you want, whatever suits your client. Arbitration's not the only option. You also have a litigation provision that you can put in there. So you can modify the arbitration, you can get rid of arbitration, you can throw in litigation. Each one has its pros and cons, which we're going to talk about. But first, I want to share this with you. So this is a quote from a book that us lawyers love to use. It's from The Law of Yachts and Yachting. There's a chapter in here that discusses the MIBA charter form in detail. So if you thought the 8 pages of the standard form was really exciting to read through, you'll find the 43-page chapter describing the 8-page form absolutely exhilarating, I promise. So I'll read this to you really quickly. Brokers and users of such forms, however, must be warned that the use of identical wording in contracts, subject to different laws, does not guarantee that arbitrators called on to decide the same dispute on the basis of the same wording will reach identical or even similar conclusions. So what does this mean, and why am I showing this to you? What I want you guys to get out of this is that changing one small provision, even something as small as like your choice of law, can affect the entire contract. You think, oh, I'm just throwing this in, it's going to change one thing. It might not, because English law is different from Florida law, which is different from New York law. It changes. If you want to know more, you can get this book on Amazon for a very reasonable price of $472. Please don't go now. Wait till I finish speaking. But it's there if you want it. All right, so arbitration. We're going to talk a little bit about arbitration, litigation, pros and cons for a minute. So what is it? I think most of you guys know, but in case you don't, it's a private alternative to court. So parties agree ahead of time to resolve disputes in front of a neutral third party. You do have to have an agreement between the parties in order to get into arbitration. So what are the benefits? One of the biggest benefits, especially for this industry, is that it's private and it's confidential. The procedure is much more relaxed than in court. The parties pick the arbitrators. So what this means, especially for this industry, again, is that you can pick an arbitrator who is familiar and well-versed in the law and terminology in the yacht industry. And when you get into something really technical, you know, with boats, it's important to have somebody that understands it. So arbitration can be less expensive than litigation, but it could also cost a lot. You just never know. It could be quicker than litigation, but it could also last a while. The biggest negative to arbitration is that it is final and binding. This means you do not get to appeal the decision. It's one and done. If you don't like the decision, if you're on the losing end, I'm sorry, tough luck. It is what it is. All right, let's talk about some considerations for if you say, we're going to leave the arbitration clause in the MEBA contract, I just need to tweak it a little bit to fit my client. What do you need to think about tweaking in your arbitration clause? So where will it occur? Likely Florida. We saw in the example that, they try to say it's going to happen in Florida. What rules will you follow? There are a lot of arbitration associations. I put a few of them up here on the side. Take your pick. Some of them are more specific to the maritime industry. What is your choice of law? Typically, if you're in Florida, it's gonna be Florida. I mean, broker, clients in Florida, always a good choice. How many arbitrators will there be and how are they selected? What is the scope of your arbitration? And what I mean by the scope, because I know that's not super clear, is that you always want a very broad scope, because what you don't want to happen is to narrowly limit or have words that seem to narrowly limit your arbitration clause, and then you find yourself with a dispute that they say, well, that didn't fit into the clause, so that's going to go to court. So now you've got a claim in court and a claim in arbitration. You want it to be broad, so if you really do elect for arbitration, everything's going to go to arbitration. All right, here is a sample arbitration clause. I pulled this out of just a standard contract book, so this isn't something that we would necessarily use to amend the MEBA form, but I put it here because I want to show you guys the detail. It seems really simple when we talk about it sometimes, but there's a lot of legalese that goes into this. It can get really long. I mean, you can have arbitration agreements that are pages and pages. All right, so that's it on arbitration. Let's quickly talk about litigation. You know what it is. It's in a court. It's in front of a judge, maybe a jury. It can take a long time. It can be really expensive. The case is public information. You are following formal procedure and rules of the court. You don't pick your judge, and your judge may not be well-versed in the industry, right? So you could spend a lot of time explaining to your judge technical yachting terms that they might not understand. But what's really great, and arbitration doesn't have this, is you have the right to appeal. So the case doesn't come out in your favor. What do you get? You can appeal it. It may be overturned in your favor. It's a big benefit of litigation. Because I know many of you are thinking, like, that's a lot of negatives. Why would I ever choose litigation over arbitration? And honestly, I'll tell you guys, one isn't necessarily better than the other. It's whatever is going to suit your client. Whatever, it's a strategical decision that you need to think about. But I'm not here to tell you that one is better than the other, or you should have one and not the other, or vice versa. All right, so considerations for your litigation clauses. There's a lot of fancy legal words up there that I think a lot of you probably are thinking, I don't know what that means. But I'm going to explain them to you, and your litigation clause should ideally have all of these things in there because they're necessary to have a really tight contract and a really good litigation dispute resolution provision. So you want to have choice of law. That's self-explanatory. We talked about that a little bit. You want to have a forum selection clause, which tells you which court are you going to be in. You want to have a venue clause, which tells you where. We talked about the where a little bit earlier. You want to have something called submission to jurisdiction, which means the court is going to have power over the parties. This is actually, it's a little bit more complicated than this, actually a lot more complicated than this, but you need it in there so that the court can actually bring these people into court and they can issue a decision and they have to follow the decision. You need a waiver of venue, so your parties can't say, oh no, you can't sue me here, it's not convenient for me, I don't belong here. And you need a service, or you should have a service of process provision, which tells you how to serve the complaint. And why is this important? Because it becomes more important in an international context. So if your owner is in Europe or Russia or Italy or what have you, wherever, not America, it can be a little bit difficult when you go to serve a complaint, right? So you want to say, hey, It's really simple. What we're going to do is we're going to serve it by FedEx, and that's it. And again, same thing here. I pulled this out of a standard contract book just to give you guys some detail. It doesn't have everything that we talked about, and it's not specifically for MIBA, but it gives you an idea that it's not just a couple of sentences, and it's not really, honestly, even plain English. It gets complicated, unfortunately. All right, so this is the conclusion. You guys, what you actually do, I know you work really hard. Your clients are unique, your yachts are unique. The standard form is good, but it's not a one-size-fits-all, right? Make it unique for your client. Make it something tailored that's going to benefit him, and that, you know, if he gets into trouble with respect to the dispute resolution provision, he's going to be protected, and there's not going to be any surprises. So you want to put your client in the best position possible. I would definitely recommend that you have a lawyer at least just look at the contract. If you're making revisions to it, tell your client, you know, hey, if you're asking for a lot of special things, or you're in, you know, a different situation, get a lawyer, have them draft the amendment, better protect you. It's a huge risk if you're doing it yourself and you don't know exactly what you're doing and exactly what you're writing. Be upfront with your client, discuss it ahead of time, make sure your client is aware of what's in the contract. You don't want him to tell you, hey, my holiday was ruined, I'm unhappy, and, you know, I want to sue. And then you have to tell him, but wait, you're not going to sue, you're going to go to arbitration, and it's going to be in London, and you got to get an English lawyer. You know, be upfront with your client, make sure that he's aware of what he's signing. And that's about it. Thank you, guys.
So I haven't spoken before you in a long time. I absolutely appreciate the opportunity to do so. I'm always honored to speak before the charter managers and brokers. It's always a lot of fun. But I have to mind my P's and Q's because everybody in here is sharp as a tack. So you asked me to come here and speak about force majeure. Funny name for a clause that has a lot of impact. And you have two contracts that right now you use globally. You have your MIBA contract and you have your AYCA contract. Those are the two contracts that were given to me. Those are the two contracts that we're going to compare and contrast. And then I was asked to answer some specific questions that you have experienced regarding force majeure and certain circumstances that exist. So let's see. Hopefully I don't have the same. Okay, your force majeure clause in your AYCA agreement. Basic language, I'm sure you know it by heart. You can probably repeat it to me. It's probably one of the most important clauses in the contract. It is going to help you get through your incidents, your omissions, and your acts of God. Now, specifically, though, what I want to talk about is this language you're going to see compared to your MIBA agreement is different in just a slight is different in just a slight way, and you'll see. So anything, we're going to go through AYCA first. Anything in MIBA when we come to second that's different to this will be in red. Okay, so what does it not include? Shipyard delays and crew changes. I think there we go. Okay. So what does it include? Strikes, lockouts, civil commotion, riots, blockades, invasions, war, fire, explosions, sabotage, storms, collisions, groundings, fogs, governmental acts and regulations. This is a clause that one of the questions is going to be based on, so I highlighted it in red. Major mechanical or electrical breakdowns beyond the owner's control and not caused by the owner's negligence. So then what about for the force majeure clause in your MIBA contract? So here's the difference. If you notice, same language except for the crew up here. That is an addition to the force majeure clause in your MIBA contract. So owner, the crew, or the charterer. So that's specifically added in there. And then there was another really nice clause that's in MIBA that I didn't find in the AYCA agreement, and that's your clause 22 regarding when it's invoked related to breakdowns or disablement, the owner shall instruct the owner's representative to submit a detailed technical report. And why I specifically put that up there is that's also addressing one of the 3 questions that was sent to me. So in here, though, what you're going to see 2 things that I think is smart that were acted. Of course, act of terrorism is in MEBA, and nowadays, probably since 9/11, I think that that's a great addition to the force majeure provision. And then also contaminated fuel, which is something that we've litigated about and something that you do experience and might not be the owner or the crew negligence or mishap. It could be, you could go to the most reputable fuel supplier and just get some bad or contaminated fuel. So I like that that provision's added in here. And then here again, you see the difference in the red language between the AYCA and the MEBA agreement is that, again, crew is added in here. So the same carve-outs with shipyard delays and crew changes. So if we move forward, some examples, just, obvious examples are storms, groundings, fire, riots and civil unrest. Unfortunately, that's not an unrealistic picture in this day and age. And of course, things that are absolutely beyond the owner's control, or if you're talking about the MEBA, the crew's control. Loch Ness Monster, Jaws, I don't know. So things that you have carved out specifically, crew dismissal, crew leaving, crew changes, crew vacation, and then of course shipyard delays. But we're going to go more into this subject because that could be interpreted in a couple of different ways. So here are the questions. So there's 3 questions. The first one we're going to talk about when proving force majeure with mechanical breakdown, who can ask for a survey, what are the limitations, and in what time frame? Okay, so here's one thing that we don't do in our industry, but that occurs very frequently in our commercial industry. And when I say commercial, I'm talking tanker, cruise ships, tugs, cargo ships. When these vessels are chartered out, they're surveyed before by the charterer. That's not something that's common in our industry. It's something that I think that prior, when I spoke to you, I would recommend it when I am involved and it's asked of me, is it recommended that I get a survey before, depending on, of course, the size of the vessel and the length and how much money they want to spend. I always say, and you're hiring me for worst case scenario, belt and suspenders, get a survey or ask for a copy of the most recent survey, assuming that the owner will give it to you. So in the MEBA agreement, though, remember that you have that clause in there specifically saying that it's up to the charterer. They have the option at their expense to survey the vessel before and after. Now, not that I saw it in the AYCA agreement, but it doesn't mean that you can't ask for it. It doesn't mean that your charter can't do it. I understand that time is of the essence for what it is that you do, but depending on the price and the longevity of your charter, it might be something that you consider or your charter consider. When could they ask for the survey? Obviously, if you're representing the owner of the boat and the charters are back to back, that's going to be a little bit difficult. So maybe you could try and schedule it in between, even if it's 24 hours, have a surveyor lined up. I know all of this sounds crazy, but it's the best case scenario. And then what are the limitations and what time frame? So I'm talking about before, of course, and then there's the after. And what the after applies to is now you have an incident, you have a mechanical breakdown, and what should each party do? So if you're the owner and there's a mechanical breakdown, either prior to or during, and the first thing that you want to do is make sure your crew, whether it's the captain or your first mate, your engineer, whoever it is, and whoever is on board and active at that time, the first thing that they should always do is contact their charter marketer, okay, the charter manager. They should absolutely call them immediately, let them know that there's an issue. Because it's all about communication, whether it's chartering or it's your marriage, it's all about communication. So the faster you communicate, the better. And of course, I'm a lawyer, so what am I going to say next? Always put it in writing. So we love telephones, we love technology, we like to get things done quickly, but I always recommend to my crew or to yourselves, if you have that sort of communication via the telephone, then please make sure that you follow it up in writing. Because when it comes to going to arbitration or going to litigation, we don't want it to be he said, she said. We want it in writing that it's easier to prove. So then what happens if you're the charterer and something like that happens and the owner calls for force majeure because of mechanical breakdown? So in that case, then what you ask is, if I were the charterer and I represented the charterer, would be, I want to see your maintenance logs, I want to see your survey report, if you have one from maybe the last 6 months, and what have you done with the vessel? And the reason why I say that is that there's been circumstances where mechanical breakdown has been used, and mechanical breakdown could be anything from, let's say the television system isn't working on the vessel, compared to generators or true engine mechanical breakdowns. There's a huge difference. So I have seen it where we've gotten calls, my charter was canceled, they said mechanical breakdown. We want to know what it is and back it up. Then the next thing is, we've seen in the past where it's mechanical breakdown, and then within a week, that boat is up and active and chartering, or being used by the owner. So again, it all is fact intensive on what actually is the mechanical breakdown, where's the support for it, and then where's the evidence that you have maintained the vessel in order for her to be chartered, and that it wasn't your negligence, it wasn't the crew's negligence. So then, I think we have a slide here just kind of bullet pointing that. Nope, here he is again. Should we start over, or do you want me to tell you about his seminar? I think I'd be completely lost. Okay, well anyway, so what it was is just a slide bullet pointing to you. There it is. Let's try this again. Okay, so there you go. So just bullet pointing the different clauses that I found in your agreements that could be helpful. And then again, it was asked of me, when do you do these things? You do these things immediately, as soon as it happens. Don't delay, don't try and figure it out yourself. Let's make sure that everybody is on board and knows what's happening. And you'll be amazed, and I'm preaching to the choir here, how much you and the audience can help mitigate the issue. So then going back, the next question is, when claiming force majeure due to a shipyard delay, how do you determine whether it's a shipyard's fault or the owner or captain's fault in planning, or owner and crew in the case of the MEMA agreement? Now, why do I have that up there? Because you're probably all going to say to me, but wait a minute, we carved that out. We specifically carved that out. Okay, I understand that. Shipyard delays are not inherent to a force majeure. But what happens if the shipyard's having a riot, or had a complete fire, or there was an earthquake, or tsunami hit it? You know, or it's in New Orleans and there's a pending hurricane, or it was just hit by a hurricane. In those cases, if challenged, those are force majeure issues concerning the shipyard versus the delay, like, let me fast forward to, okay, to the slide. So how about the difference is, right before the charter, the owner decided he wanted to change the color of the hull. Put it in the shipyard, subcontractors delayed. That's legitimate reason to carve out shipyard delays. But if the shipyard is under some sort of natural disaster, or there is strikes or riots, then you've got to ask yourself on whether or not that clause is going to hold up in court. And it goes back to, of course, every time you guys ask me to speak about something, it's never black and white. It's always gray. It's going to come down to the actual facts of the scenario, and that's why you need to make sure you put everything in writing and document your case. Because when it comes to issues like this, these are the issues that are going to end up with Stephanie on arbitration and litigation. So let's go back one to the last question, because I know I'm running out of time, if I can. Or you guys can control it for me. No problem. Just want to read out the last question because I don't believe that it was given to you. Go back one more, sorry, to the questions. There we go. What happens when claiming force majeure due to hurricane, storm, or devastation to an area, but the cruising grounds are still fine? Is that actually force majeure? Very good question, and of course, a very current question considering that we just went through tropical storm watch, warning, hurricane watch, warning, and then look what actually happened here. Thank God nothing really happened in our South Florida region. But what's the realness of this? Because I get it. I mean, I believe me, the morning of Hurricane Andrew, I was here in Fort Lauderdale with my mother at the beach because it was gorgeous out, right? So one could say to themselves, well, I don't understand. Why can't they still come board and get out of harm's way? It's beautiful. The seas are calm. However, you have to think of the other things that might be going on during that storm. Airports are closed. There's governmental warnings. Maybe there's forced or recommended evacuations. That's going to all affect, one, the charterer getting here. Now, granted, most of these charterers have their own planes, but when an airport closed down, an airport's closed down. So I don't care if you have your own plane or not, it's not getting in or it's not getting out. So it might be the most beautiful day recorded in the year. However, there's other factors to understand that a hurricane is a hurricane, or a natural disaster is a natural disaster. Think about the other effects that might be going on. And again, those are the governmental warnings. What effect is it having on transportation? Also, can your service providers that might be provisioning yachts, can they get what they need to get to that yacht? So it's more than just, well, it's beautiful out. Why can't they just get on the boat and go? So when somebody is claiming force majeure, and that goes both ways. It could be the owner saying, listen, I'm not going to let, it might be gorgeous out, but we're under hurricane warning. Force majeure because of weather. And it could work the other way. Owner could be saying, it's beautiful out. I don't understand why these charters can't just get on the boat and get going. Charter can't get here, you know? So think about it for two ways. And then, of course, one of the biggest implications on this is insurance. What is the owner's insurer going to say about that? And let me tell you, whenever it comes to you calling me about this, and one of my first questions is, do you have the insurance policy? And let me review it first. Because I could say one thing, but the insurance policy might dictate something completely different, which I might give you the advice to go ahead with it, but the insurance policy is saying, absolutely not, no way in hell, and if you do, guess what? You're not covered. So we wouldn't want to ever challenge that. So these are the questions that were asked. These are our recommendations. Again, nothing black and white, I'm sorry to say. But at the end of the day, it goes to the contract. Another question that was asked separately when I actually walked in is, what can you put in a force majeure clause and what can't you? You know, you have to be reasonable. I know that was a very good comment, I think, Terry, you said about the Zika virus, right? Are you going to put just as, how could you claim that I'm not coming to Florida because there's 2 zones, one in Miami Beach, and I believe the other one was Windward. Well, you're not boating, we're not bringing the yacht to Windward for you to board. You know, so let's be reasonable with that. But if there's an outbreak of Ebola because a hurricane just went through and there's dysentery, well, no, that's completely different. So it all goes to look at your contract, your 4 pages of the agreement, understand it, change it, like she said, before it's signed. Otherwise, unless you get both parties to agree to addendum, to amend it, it is what it is. Lastly, and a very good point for everybody to know, who's under the obligation? It's whoever claims it. So if your owner is canceling the contract due to force majeure, they're under the obligation then to prove it. Or vice versa, if it's your charter, the same there. So thank you very much for having me. It was always my pleasure.